Justice Jackson?
Good morning, General. So I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought, and that might or should matter for standing purposes. I don't know that our doctrines sort of capture this, but I guess I see it that the injuries that the respondents allege, as you've articulated them, are a conscience injury, that they are being forced to participate in a medical procedure that they object to. And so the obvious common sense remedy would be to provide them with an exemption, that they don't have to participate in this procedure. And you say, and you've said here several times, that federal law already gives them that. So I guess then what they're asking for in this lawsuit is more than that. They're saying, because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that, given the injury that they have alleged.
I agree, Justice Jackson, and I do think it's relevant to standing. There's a profound mismatch here between the claimed injury and the remedy they were seeking. And, you can almost think of this as a type of zone of interest kind of analysis. If the doctors have a conscience injury, there's a specific statute designed to deal with it, to specifically tailor-made guard against the risk of that injury occurring. And instead, they're reaching out and seeking to invoke rights under a different statute, the FDCA, that doesn't regulate them at all, that doesn't make them do or not do anything, and the relief that they're seeking would dramatically alter the approved conditions of use for Mifepristone and affect women all around the nation simply because of this conscience injury that's already directly addressed by other protections.
Right, and if it wasn't addressed, then we would see this lawsuit, and the remedy would be to exempt them. Right?
Yes. I think that one of the hard things about trying to tailor relief here is that they're asserting such a diffuse theory of injury that it's almost as though the only option was to grant a nationwide remedy of the kind the lower courts issued, and that runs counter to ordinary Article III principles of party-specific relief. But I just think it shows that there's something wrong with the theory of injury in the first place because it's so attenuated and because they claim they would need so much relief all over the country.
Let me ask you another question. In addition to the challenges that we have here, the respondents below challenged the FDA's initial decision to approve Mifepristone in the year 2000. Of course, that occurred a very long time ago. The Fifth Circuit found that challenge wasn't timely because of the statute of limitations. As you're aware, in the context of another case we heard this term, the court is currently considering the statute of limitations issue. So setting aside standing, have you thought about how a ruling from this court on the statute of limitations in either direction might impact what happens in these kinds of cases with these kinds of challenges?
Yes, I think that it just reflects the stakes of the corner post case and provides a vivid example of the way that it might be possible if this court were to approve the request for a broader theory of the statute of limitations in that case, the way it could open the door to plaintiffs coming in and saying, well, I only became a doctor later, or I only started working in an emergency room later, and would try to unsettle longstanding agency actions that maybe occurred decades previously. I do want to say that I understand the corner post petitioner to have suggested maybe there would be equitable defenses that the government could raise in those kinds of cases. We would certainly want to raise that type of defense with respect to the approval of Mifepristone, which I think has generated tremendous reliance interests and proven to be safe and effective over decades of use.
Thank you.
Thank you, counsel.